The next case is Orlando Regional Healthcare Systems, Inc. versus Florida Birth-Related Neurological.
May it please the Court. My name is Brad Blystone. I'm here for Orlando Regional Healthcare System. I'd like to reserve approximately 4 minutes of my time for rebuttal if I could.
Okay.
The good news, I think, for the Court today is I'm bringing a NICA claim, a birth-related neurological injury claim under the Florida statutes, but not under a notice issue, as this Court has recently addressed in both the Alexander and the Weeks case. What I'm addressing here today with the Court is errors as a matter of law made by the administrative law judge in two respects. First, the administrative law judge failed to consider the statutory rebuttable presumption in place in Florida Statute Section 766.309. And then second, the administrative law judge erred as a matter of law in his statutory construction of the defined term birth-related neurological injury under the Act.
Rebuttable presumptions are subject matter of the evidence code, correct?
Yes, Your Honor. They would be even in an administrative proceeding.
And those address factual determinations?
Well, they would address factual determinations, but legally they have to be considered.
Well, the factual determination in this case is you've got the factual determination as to whether there is a compensable injury, brain damage, and then you've got a legal issue as to the meaning of immediate.
Correct.
Well, you're not suggesting that the rebuttable presumption addresses the legal determination of what constitutes immediate.
Correct, Your Honor. Two separate issues on that, yes. The rebuttable presumption...
And there is no dispute in this case that there was a brain injury. It's not like Nagy where the dispute is whether the injury itself was a brain injury. In this case, all parties agree that it's a brain injury, and so the question really, the fundamental question in this case, is the definition of the word immediate, correct?
That would be the threshold issue. In other words, the rebuttable presumption is critical from the standpoint of it's in place because the legislature recognized that if you can prove a brain injury occurred as a result of oxygen deprivation or a mechanical injury, then the rebuttable presumption is in place. In other words, you don't have to prove when it occurred. That's the purpose of the rebuttable presumption. If you can prove the two elements that there was an injury and it was caused by oxygen deprivation under the rebuttable presumption, then the burden shifts to the opposing party.
Well, but the rebuttable presumption can't expand the Act, can it?
No, Your Honor, and we're not asking for an expansion of the Act. As under the Fluid decision, we're saying this is an incorrect reading of the Act. We're not looking to expand the definition. We're looking for a correct interpretation of the definition. And as Your Honor says, the threshold issue then would be the term immediate. And the error in law that the judge made in using the term immediate is the statute reads that you can have a legally defined birth-related neurological injury in labor, delivery, or resuscitation in the immediate post-delivery period. So you must be able, under the reading of the statute, since it says or and it's in the disjunctive, you must be able to have an independent injury then during resuscitation in the immediate post-delivery period. What the ALJ did here was he equated the term immediate with a meaning of a code. And as I pointed out in my brief, a code is just simply a term used to define when healthcare providers are called for resuscitative measures.
Immediate isn't defined within the Act.
Correct.
And as a result, the ALJ had to struggle with the issue of how you define that term.
Correct.
And in your brief, you suggest that it can last for years, which I don't know, a decade? Could it last a decade?
In my brief, I'm suggesting no, not in this context. I'm saying the term immediate, depending on the context in which it is used, can be a time period of seconds, minutes, days, or even years. And in this circumstance, I drew the court's attention to the medical terminology of an immediate amputation. Now,
but that's a different statute with different purposes. The question is, how again does the ALJ go about defining the phrase immediate?
Well,
should he go to the medical doctors for that definition? Does he go, as he did, what he did was he went apparently to a dictionary definition, giving the word its ordinary plain meaning, whereas you would have had the ALJ accept medical definitions where there really wasn't much of an agreement necessarily on medically what immediate would mean.
Well, my response there is, as this court did in the Alexander decision, the court recognized that you can, in this statute, when looking at terms such as mental and physical injury, you can go to medical resources. This court specifically said that there. And that's what we think the court should have done here, the ALJ. He should have listened to the medical terminology, because this isn't semantics. He connected the term immediate in the wrong place. The statute says resuscitation in the immediate post-delivery period. What he has done is he has put immediate over in front of resuscitation. He's saying that we equate this, I equate by reading a dictionary definition as immediate to attach to resuscitation, because he defined it as the time period of the code. So he's saying you can only get a defined benefit here if you have an injury during immediate resuscitation in the post-delivery period. Our argument is that the resuscitation was continual, and it can last for more than just a few minutes during a code. As a neonatologist testified, as a pediatric neurologist testified here. In looking at the term as a whole, they're saying they admitted that this actual whole phrase is not used in a medical context, but they know what each term means. And they looked at resuscitation first, and they said, well, look, everyone agreed. All the experts, even NICA experts, agreed that there was resuscitation going on a continual basis here. This child needed resuscitation beyond just the time of the code.
Address this from a different perspective, and that is, am I correct that your two experts said that there was brain injury, it was their opinion that there was brain injury during labor or delivery?
One expert testified that he did believe, the pediatric neurologist believed that, yes, it started then during labor and delivery. Now, then it goes to the substantial part. They're saying even NICA's expert admitted that there could have been oxygen deprivation that would have been causing some brain injury immediately after birth. But then it goes to, well, when was it substantial enough to be a substantial mental and physical injury? So even NICA's expert conceded that, and my pediatric neurologist did say that due to the fact, and this is an expert who deals in determining when brain injury occurs, unlike NICA's expert who doesn't. He said that by the fact that the child was not breathing at the moment of birth suggests there was already a mental brain injury going on, because the brain was not telling the body to breathe. Something had already occurred in utero. So that's where the ALJ made the error here.
Was that Dr. Brill or Dr. Ryan?
I'm sorry?
Was that Dr. Brill or Dr. Ryan?
Dr. Brill. He is the pediatric neurologist. Dr. Ryan is the neonatologist out of Stanford University. Now,
given that the ALJ was only reading deposition transcripts, and we're in just as good a position to read deposition transcripts as the ALJ, why do you think, if you do, that Dr. Brill's explanation or testimony or opinion that there was a substantial brain injury during labor and delivery is more persuasive than the other opinions?
For this reason, the NICA's expert here, and this is where the rebuttable presumption comes into play. If it was in effect, they could not have rebutted the presumption because NICA presented the opinions of an obstetrician gynecologist, or in this case, a maternal fetal expert. He's board certified in maternal fetal medicine, although he doesn't deliver babies anymore. He even admitted, he goes, I take care of moms during the labor, I deliver the child, but then after that, it goes into the realm of a neonatologist who then takes care of the child. He may be involved with some resuscitative acts just because nobody else is there at present if he has a child who's not breathing and who comes out of the womb before a neonatologist get there, but he does not have the expertise, and he conceded he did not have the expertise to address brain injury beyond what he defined as the first 10 minutes of delivery, what he thought was the immediate, or the resuscitation in the immediate post-delivery period. He conceded that from that point on, he could not determine when or if the child would have a brain injury. So their expert was not qualified to talk about what occurred, which was our argument, that a brain injury occurred during resuscitation in the immediate post-delivery period, which we're arguing is more than this arbitrary term of a code, because if you limit it to just a time period of code, as the ALJ here did, you're essentially abrogating part of the statute. If a child comes out, a child is born, and the child is not breathing, and no resuscitative efforts take place, just as NICA's expert admitted, then you may have a compensable injury. Then, the child will undoubtedly sustain brain damage. But nobody's going to do that. You have to resuscitate during those time periods, and you're providing oxygen, and you're providing a heartbeat for that child if necessary. So
now the parents, obviously, of the child are not here contesting the actions of the administrative law judge, and the appellee takes the position in their brief that you are not a claimant pursuant to the Act. Would you respond briefly to that?
Yes, I have several arguments in response to that. The first is the claimant in this case, the parents, at the beginning were given an opportunity to present their testimony, and they said essentially that we, the hospital, was taking up their argument and presenting it to the ALJ. So one, I would say they adopted. We stepped into their shoes then and would be entitled to the rebuttable presumption. The second is, under this court's Alexander decision, there the plaintiff was trying not to get NICA benefits. They had to go there. They applied. They didn't want them. And the court used the rebuttable presumption against them. So they were parties. They were parties, but if the point is that the presumption only inures for the benefit of the claimant, then that's not true, because they wouldn't have presented any evidence to entitle themselves to the rebuttable presumption there. The hospital, again, presented testimony in that case to establish the rebuttable presumption, and the court used the rebuttable presumption against them then in the decision in saying it was established. And then the burden shifted and there was no contrary evidence. So that's why we would say this. The third reason would simply be...
On appeal, they have not joined on the appeal, have they?
No. They have not joined or participated in this appeal. That's correct, Your Honor. So the point is, I think what the ALJ should have done here is, obviously you can look to a dictionary, but the dictionary is only taking you so far in something like this. You must look to the legislative intent. As I pointed out in brief, if you really look to the legislative intent, what the legislature was trying to do here, the legislature was setting up a compensable process and a no-fault system for birth-related neurological injuries that could independently occur in 3 separate time periods: labor, delivery, or resuscitation in the immediate post-delivery
But the
period.
legislative scheme is for that to be a limited class of cases.
Again, it's to be a limited class of cases, but then the statute must be defined in such a way that it makes sense and abides by the legislative intent. Here we know, in a situation where an injury can occur during labor can last for hours, even days. then the delivery process may last for hours, to then arbitrarily limit the resuscitation in the immediate post-delivery period to a few minutes, I would argue, does not comport with what the legislature was trying to do here. The legislature said we will provide compensation to injuries that occur during resuscitation.
So factually, in this case, your defining moment where it goes from immediate to beyond immediate is when the child is placed on the heart-lung machine?
I would suggest that the proper interpretation, and the only way to look for interpretation in a statute like this, besides looking things up in the dictionary, but again taking it in context, is to listen to the medical experts. All of the medical experts, if you read the definitions that they provided for this terminology, all came back with the term stabilization. In other words, they were looking to say, well, resuscitation essentially ends when the child is stabilized to the extent that you can expect no further injury to occur. And
isn't there some evidence in this record that, as I understand the timeline, that the child was delivered about 12:48? Aren't there some nurses' notes indicating at approximately 1:05, once the child was placed onto a ventilator, that the status was fairly stable?
Well, no. I would argue no. There's never any notations in the actual documentation of the medical record itself that this child was fairly stable. There was no testimony during this time period that the child was fairly stable. The ALJ used that terminology, I would argue, in his decision, but there's nothing in the record to support that. I would like to reserve the rest of my time, my 4 minutes, for rebuttal, if I could. Thank you.
A little over 4 minutes.
May it please the Court. Good morning. My name is Robert Brace. I represent the Florida Birth-Related Neurological Injury Compensation Administration. And
Mr. Brace, let me ask you first to address why should we listen to OBGYNs over a neurologist in terms of testimony and an opinion as to when brain injury occurred or substantial brain injury occurred? Seems like that is, logically within his realm of expertise and not necessarily within the realm of expertise of an OBGYN.
Well, I think what happened here is the ALJ listened to Dr. Rhine, which is a neonatologist, and it is Dr. Rhine's testimony that Judge Kendrick found most probative. It is Dr. Rhine, as I understand the record...
Why is a neonatologist more credible on the issue of when a brain injury occurs than a neurologist who deals with brains, as I understand it, to sort of simplify it?
Well, I think it is entirely within the province of the ALJ to reject this pediatric neurologist testimony, Dr. Brill, based upon statements he made that were what the judge found to be just completely erroneous. Dr. Brill made a statement, for instance, about the cord gas that was taken, and that the fact that it reflected resuscitation attempts that were made on the child, when in fact the record did not support that. And it was rebutted by, for instance, Dr. Rhine, who is the neonatologist. So I don't think it's just simply taking the testimony of a neurologist and rejecting it. More importantly, it's looking at all the doctors, and I think the judge weighed all of the evidence. And this is a competent, substantial evidence question. The record is clearly supported by competent, substantial evidence. There was an ample record here in terms of medical records, and there were 3 experts, all within their own unique qualifications, who could answer the question.
You're using the typical rule of deference that appellate courts apply to the fact finder, but isn't it true that there's plenty of case law saying that when the fact finder is simply reading deposition transcripts, that the appellate court really doesn't give much deference because we're in just as good a position to read transcripts as the
case law does say that, Your Honor. The appellant even points out the Walton case, the estate case, as standing for that proposition. But I think Walton also says, right after the holding that the appellant referred to, that there still has to be a presumption of correctness attached to the trier of fact and to his or her weighing of the evidence. So yes, you're in a position where you can read the cold record, and you might even find that Dr. Brill was the most probative. You may like Dr. Brill's testimony the most. You may even reach a contrary conclusion to the ALJ, but that's not the test. And as the court pointed out, it's all about competent substantial evidence, and the record does support that there was competent substantial evidence to arrive at Judge Kendrick's ultimate ruling.
There's a rebuttable presumption of a compensable injury here, and the ALJ is making a finding that I believe it ended, that immediate ended about 105, as I understood the record here. What competent substantial evidence is in this record to overcome the rebuttable presumption of a compensable injury that at 105 this child was stabilized and therefore not subject to the act?
Well, I think we have two issues there, and if I may for a minute, I want to break them up. With regard to the rebuttable presumption, it's almost as if the appellant is urging this court that it's irrebuttable, that there was a brain injury from oxygen deprivation and there was a permanent substantial mental physical injury. And
I think the point is that I can't see any indication that the ALJ recognized that there was a presumption at all and applied it. Is there?
I don't know if the ALJ recognized it or not. It's certainly not referenced.
Wouldn't that be an error if the ALJ didn't apply the presumption or consider it?
I do not think so, because the result would not change. And the reason I say that is, again, it's not irrebuttable, and there was competent substantial evidence to overcome it.
You're answering the question of what is that evidence? So
the evidence is primarily Dr. Ryan. Dr. Ryan was the expert called by the hospital, and Dr. Ryan, I think, was very clear in his testimony. He was not able to say that there was any hypoxic injury during labor and delivery. When questioned about the resuscitative period, the immediate post-delivery resuscitative period, he timed it out to 2.5 hours. And he talked about, well, there may have been some things that occurred before then, but they weren't substantial. And he talked about in and of themselves, by themselves, they could not or did not, he couldn't tell if they caused a hypoxic injury. So I think Dr. Ryan's testimony, which was brought forth to the court by the appellant, was found most probative. And the court also looked at Dr. Willis's testimony in conjunction with that. So with regard to the presumption, the result doesn't change. It was rebutted. Alexander has pointed out in the reply brief by the appellants as somehow standing for the proposition that absolutely the presumption should have applied here. But
I guess the concern I have with your argument is taking everything is, say that you're right on, and there is evidence that would overcome the presumption. I mean, it's possible, the concern is if the ALJ didn't use the presumption and simply said, okay, I'm weighing this evidence and I come out this way, he might have come to a different result if he had started from the framework of, okay, there is a presumption that this is the outcome, and rather than asking which of these doctors do I find more credible, the question he asked is there enough evidence on this side to overcome not only the testimony of the doctor, but the presumption, the answer might have been different. And I can't tell that he went through that analysis at all. So again,
the only way the result would have been different, possibly different, not different, but possibly different, is if the judge had accepted the testimony of Dr. Brill, the pediatric neurologist, and he specifically, explicitly rejected his testimony in terms of there being a placental hemorrhage sometime during labor and delivery. And the rest of the opinion, the ALJ accepted and said was consistent with Dr. Ryan's testimony. But the judge just didn't say, Judge Kendrick just did not say, I'm rejecting Dr. Brill's testimony, I didn't like it. I mean, he pointed out a glaring problem with his testimony in the record. And he said, this is so glaring that I cannot accept what this man says in terms of the timing of the injury. So if you remove Dr. Brill, as the ALJ did, there is nothing else there that would support there being an injury, an hypoxic injury, during the immediate post-delivery resuscitative period.
Let me ask you.
Counsel,
Go ahead.
Yes, ma'am.
Doesn't Dr. Ryan specifically reference that all of these incidents are contributing to the injury all throughout, and that it just becomes substantial at the 2.5, and he can't tell at what point the injury occurred? So even taking Dr. Ryan's testimony, it appears that he's indicating that there could be some contributing factors throughout the immediate birth through the 2.5-hour period.
He did acknowledge that, Your Honor, but he also says that in and of itself, and looking at those events, that he really couldn't pinpoint them on that. And I think it's also important that you look at both the injury occurring during those 3 periods, labor, delivery, or the post-delivery resuscitative period, and the hypoxic injury occurring during that period.
But in response to one question, he specifically said the time frame of the immediate post-resuscitation period is the moment of birth at 12:48 until that 1944 time frame, correct? Correct. That's Dr. Ryan's testimony that it appears that Dr. Ryan might be answering a little bit different depending on the question, but there is substantial competent evidence in this record that he was of the opinion it started right at the time of birth. Do you disagree?
Yes, I do. I think that the judge weighed the various testimony. Is Dr. Ryan crystal clear in his testimony? No, but he is crystal clear that there was no hypoxic injury, at least within reasonable medical probability, that occurred during labor and delivery.
So are you equating hypoxic with substantial?
I think that, no, hypoxic, I'm saying, is oxygen deprivation, but I think substantial is something that needs to be there, yes. I do.
Let me ask you this. With respect to the term resuscitation, I mean, it's not defined any more than that, but I would think that in the medical context that would be cardiopulmonary resuscitation. Would you agree with that?
CPR, I think, could be one form of resuscitation. Yes, sir. I think the judge, in his attempt to reconcile that in that statutory term, did it correctly in terms of using the ordinary and common usage of the term, and he acknowledged that in his order.
It seems clear, as a practical standpoint, that there was cardiac resuscitation when the code was over, but there was never pulmonary resuscitation in that the child never breathed on his own. Isn't that correct?
That is true. The child never
I'm
breathed
having
on
a
his
hard
own.
time understanding why the resuscitation period ended before the resuscitation itself was over, because the child was not resuscitated if the forced breathing had to occur, correct?
Yes, but you have to give meaning and intent to the word immediate. I mean, it's a very important
But
term
why
in the
would the
statute.
resuscitation period end before the resuscitation occurred? And I don't think that it did if the heart started beating by itself, but the child never could breathe on his own.
Well, I don't think you can look just simply at the breathing. I think Judge Cohen pointed out quite correctly that if you used the rule or the definition that the appellants are urging upon this court, that it could go for years. And that is simply not what the legislature intended. I mean, this is in derogation.
And I want to ask, where do you draw that line? Resuscitation is an ongoing event. So where do you draw that line? Where does immediate stop and we get past this act, where does that begin?
I don't think, Judge Cohen, that you can draw a bright line test. I think it is case by case, and I think that this order does not stand for the proposition that resuscitation in the immediate post-delivery period is rigidly tied somehow to this code Blue 45 being called.
So then is it defined by the, on a case-by-case basis by the doctors?
The doctors can perhaps provide probative testimony, but I think most importantly here, Judge Kendrick looked at the terms in the statute and applied their ordinary and common meaning. I think that there's no technical significance to that immediate post-delivery resuscitative period.
But he ends it at 105. And
yes,
what evidence is there in the record that sustains, competent substantial evidence that sustains that finding?
I think the record reflects that the child's coloring was better at that time.
Well, they had a bag. They were manually, making sure that this child, had oxygen going into the lungs. That's it? That's immediate for purposes of the act? As long as someone's there with a bag, as long as he's put on a ventilator, heart, lung, I mean, how do you make that decision? How do you make that delineation?
I think it's case by case. I think the judge recited the fact that there was some improvement to the child. I think the appellants disagree perhaps with that characterization, but the judge did reflect in his order and did cite to the record that there was some improvement in the child. The APGAR scores did improve. The heart rate, I believe, did go up. Coloring did get better.
Certainly the child wasn't breathing on its own.
The child, to my knowledge, I know of no place in the record that he was independently breathing.
Isn't that consistent with the hyaline membrane disease? I mean, that's a lung function problem where the air sacs aren't filled, they're closed, and so the air has to really be forced in.
It can be, yes, sir, and I think it is reflected in the medical records that they were perhaps trying to rule in or rule out that specific disease process. So, yes, I do think it is consistent.
Is it a function of the aspiration of fecal material?
Well, I think that it's undisputed that there was meconium passed in utero and that there was meconium aspiration by the child. I think there's some conflict. It's not necessarily important to the resolution of this case on appeal, but there's some conflict. Was there a maternal fetal infection? How did it contribute? And so on and so forth.
Was the hospital a planned participant?
The hospital, as I understand, and I believe it was stipulated in the pre-hearing stipulation, was a planned participant. Yes, sir. I would also note to the court that the presumption is not accorded here to the appellants because the statute is very clear. It is the claimant that was pointed out in our brief.
How do you square that argument with the Alexander case where the presumption was applied against the claimant and not to benefit the claimant?
Fair question. The way I read Alexander, it was more of a constitutional challenge. It was as applied and facially. But the difference in Alexander, if there is a big difference, and I think there is that in Alexander, the claimant actually put on a case, and the claimant in Alexander, when it went on appeal, was the appellant. And this is contrasted by what we have in the proceedings below in this case.
But your argument to us is that the presumption is only to be applied to benefit the claimant, as I understand it, that's what the statute means.
Well, I do think Alexander can be read that the presumption could get applied both ways. But with regard to Alexander...
And how do you deal with the factual issue, and that is that the claimant's attorney did say at the hearing that the hospital is going to be presenting for the claimant?
I don't think we can read too far into that. I don't know what was meant by that. And the fact is, in the petition, the claimant does not allege that there was a birth-related neurological injury and that he was seeking compensability. In the pre-hearing stipulation, there's no indication that they're seeking compensability. They're certainly not a party to this appeal.
They filed for compensation under the plan, didn't they? I mean, that's what started.
Because they have to. I mean, it's an affirmative defense in any...
Oh, no, they don't have to.
Negligence action.
They don't have to. They could file a med-mal action and then wait for this to be raised as an affirmative defense.
Absolutely.
And then the circuit court has jurisdiction to make that determination.
Absolutely. And it presumably was a strategy decision by the claimant in terms of how they presented their case and what they did. So they elected perhaps to proceed with NICA before proceeding with medical negligence action. I don't know what their strategy is.
So they want to put their case on and lose.
Pardon me?
They want to put a case on and lose.
Well, it takes care of that affirmative defense, certainly, Your Honor. So, I mean, it would not be the first time in my experience.
Okay.
So, we would certainly urge affirmance of the order in all parts, and the judge's legal interpretations have not and cannot be shown to be clearly erroneous. Thank you.
Thank you.
Thank you very much.
Two quick points I'd like to address with the court. First of all, on the question of the rebuttable presumption, to quickly take care of that, I think the court has recognized that the ALJ did not apply it, and by not applying it, the ALJ engaged in the wrong type of analysis. In other words, he was looking at the credibility of the experts versus the competency of the experts. If he would have been looking at the competency of the experts, then applying the rebuttable presumption in this case would have had a significant effect. In other words, he would have had to have said, all right, the rebuttable presumption is in place because I know I have a hypoxic injury occurring here. And so the only question is when, and it's a hypoxic brain injury. So he should have been looking to shift the burden to NICA to say, okay, what do you have as competent evidence to rebut that, to say that there was no birth-related brain injury due to a hypoxic event. And the only evidence that they could produce was through their expert, who is a maternal-fetal medicine specialist, whose time frame is limited to the labor and delivery period, and by his own admission is not competent to assess brain injury due to a hypoxic event later on. That's why the rebuttable presumption is so critical in this case. The second is on the question of where do you draw the line? And that is the critical question from the legal interpretation standpoint here. This is a statute that deals completely with medical issues. And as the court recognized here in the Alexander case, it takes medical testimony, it takes review of medical articles and medical subjects to know how to apply this whole statute medically. That's why I think what the ALJ should have done here and what this court should instruct the ALJ to do is to listen to where the experts drew the line for resuscitation here and when it ended in this context of resuscitation in the immediate post-delivery period. All of these experts look to a stabilization process. When resuscitation ended, when the assistance with the heart rate ended, when the assistance with the ventilation ended, to the point where the child should not suffer any further harm or damage. And in this case, both a pediatric neurologist and a neonatologist who deal with those issues and deal with the children on those issues testified that that time period basically ran in this particular case up until the child was stabilized by being placed on a heart-lung machine to the point that they took over all functions of this child and no further injury could occur. That's what I would urge this court to do, is to reverse this case to the ALJ, ask him or instruct him to defer to the definitions that were provided by the medical experts for this time of resuscitation and apply the rebuttable presumption in this case. Thank you.
Thank you very much.
Well-argued
on both
case.
sides, yeah.